All right. By my clock, it shows that it is 8:30, and we're going to go ahead and promptly start at 8:30. Your attorneys, we like to start promptly on time. I'm sure we're going to have a lot of other folks continue to join us. But as the slide says, this is the Cook-Brown Annual Legal Update. And for those of you that I have not had the opportunity to meet before, my name is Lisa Ryan. I'm a partner here at Cook-Brown. And I have had the pleasure of organizing, leading this annual update for 19 years. This is my 19th annual legal update. And unfortunately, this is the first time we have not had the opportunity to do this in person. The 18 prior legal updates, we've had the opportunity to have a breakfast forum where we've gathered in person. I think the first one was at the Sacramento Club, and we've last year we were at the Sutter Club and a variety of other places in between. But sign of the times, we're doing this remotely, and I'm disappointed that we don't get the opportunity to see each other in person. But one of the benefits, I guess, is that we're able to get together with folks that maybe wouldn't have the opportunity to drive into Sacramento. And hopefully this is convenient for some of you that are out of town, or maybe just can take time to spend the next 90 minutes in Sacramento with us. I'm joined today, I'm really fortunate to have two of my colleagues with me. I have Dylan Rupchock, who was with us last year as well and presented. And Dylan has been with us for a little over a year, actually a couple of years, because he joined us while he was first in law school. And we were fortunate enough to convince him that employment law is the best area of law to practice, right, Dylan?
Yes, yes.
So we're blessed that he decided to stick with employment law because it is just an ever-changing and exciting area to practice. And he will be sticking with us after I hopefully don't scare you to death with spending the first half hour or so talking about COVID matters. He'll bring you up to speed on some ever-changing areas of wage and hour law, and talking about a couple of changes to prevailing wage matters that he's been following and tracking, and talking about some trends with discrimination and harassment. I also have the pleasure to introduce another one of my colleagues and new to us, and we're just really thrilled to have him, Ian Sangster. Ian comes to Cook-Brown earlier this year. He's got an extensive employment law background, had been representing employment public entities, unions, and public sector employees, has extensive experience in arbitration, grievance procedures. So he brings to us a wealth of knowledge. We're just thrilled to have him here with us. And he, again, after I talk about a variety of different issues, you guys are going to be glad to have a break from listening to me for so long. And we'll bring you up to speed on some changes to some kin care law, some changes to the California Consumer Privacy Act, some updates there. And then he also is going to be talking to you about an area of law that is really pivotal, and I know has impacted a lot of our clients in the last few years, and he's just dove in quickly these last few months, and that is PAGA, the Private Attorney General Act. He already had extensive experience with dealing with some class actions, and then we're going to be talking about some of the trends that we're seeing with PAGA, so he'll be talking to you about that as well. Some housekeeping matters I wanted to bring everyone up to speed on. We will be providing copies of these slides. These are dense slides, and I know from doing these presentations for many, many years, you try not to put too much in slides. I get it, but I don't want you to have to spend the next 90 plus minutes trying to copy all this down. We're providing you the slides. I do have to do the attorney disclaimers that we ask you to please not be passing these slides out. These are just for informational purposes only, like any kind of, they're not intended for legal advice. It really is just kind of a snapshot when it comes to what we're seeing right now with respect to legislative updates. As you're going to hear, I always, when it comes to legislative updates, these things can be messy. I really think this year more than ever, some of these statutory updates are extremely messy. I think there's going to be legislative cleanup that's going to be required. So I really caution you from taking these slides and just running with it and taking them as advice. You need to go back. We need to take a look at the statutes. But again, I want you to be aware that you will have those sent to you. Additionally, we do have the Q&A open. Steve McCutcheon, you may see his slide up there. He's going to be monitoring the Q&A. We're going to be moving fast. There's not a lot of time to be stopping and answering individual questions, but what we're going to do is we're going to compile, if we see themes of Q&As, to try and take any kind of themes of FAQs and respond when we send out the slide decks. There's kind of common questions to those FAQs in those responses. Additionally, I want to just kind of give a little bit of a shout out. We have a lot of people registered, and I want to, just say, we recognize this has been a hard year. It's been a hard year for everyone. We know there's a lot of things going on right now, obviously at the national level, as we await finalization for results from the presidential race. We recognize all of the challenges that have happened with COVID, and we're going to be talking about those from a legislative update. But really a theme I want to talk about as we head into talking about these legislative changes is talking about your HR group. And the folks that are listening right now, we recognize that if you're spending the next hour and a half listening to these legislative updates, we recognize you're the people that have had a tough year. You're the ones that really have had to take the time to get up to speed on these laws, and we recognize this is hard. Hopefully those of you that registered ahead of time, you got an individual link. We sent out individual personalized links, so hopefully you got a cup of coffee that you'll be able to use that because, hopefully you can sit back, have a cup of coffee and just listen to this information. We also want to put a message out to all of you and to your teams, and maybe to the business owners that are listening, or if you are the HR person, send this information off to your upper levels, that you need resources going into 2021. And I really mean this. Rely on your trade associations. For those of you that are part of trade associations, you need to get involved. If you cut back on getting involved in trade associations, chambers of commerce, things like that, get back involved. It's well worth your research. You need that backup. HR compliance type backup and resources. You are going to need resources. Grow your HR departments where you can. I realize everyone's growing, having to cut back and go lean and mean, but this is not the year. This is a lot of information we're covering. It's hard to keep up, and whatever you can do to advocate for your team. This is no longer where you can be an HR shop of one. We are here, we're in your corner, whatever we can do to help you as your attorneys, but you need help to be able to comply with all of this. It is a lot. And so I'm just saying, we've got your back, we're with you. We know this is tough stuff, but whatever we can do to help and advocate for you, to recognize that you're going to need some additional help and some backup, and there's great resources out there, and whatever we can do to help point you that direction, please let us know. All right, so we're going to go ahead and delve into this as we get into some of these legislative updates here. Ran a little fast. I just had to share with you that some great support here from Sandy that helped us with our slides. That was our little COVID guy. So the first part of our breakdown is all legislative updates. And so I just want to be really clear, this is not a whole COVID presentation. This is our legal update. We did a COVID kind of breakdown back in both April and June, where we were just talking about trying to get through the COVID times. But this first part of our legislative update is talking about the legislative changes that focus on COVID type bills. However, before I jumped into the COVID type bills, I wanted to kind of have a snapshot of where are we? Where are we when it comes to just paid sick leave? So if we remember back, if we're looking at March 1, basically before COVID started, where were we? All California employers were required to provide paid sick leave, right? The Healthy Workplaces, Healthy Families Act. All employers in California were required to provide 24 hours or 3 days of paid sick leave. That was just that's been on the books for a few years. Employers usually either provided paid sick leave or PTO, and we'll end at the very end about some trends and some recommendations. Some people are moving away from PTO back to sick leave because of all these different pots that we're talking about. And then what happened? Then we moved federal law. Congress basically said, okay, COVID's popping up. What's happening? We need to have a response to COVID. So they passed in response to COVID, the CARES Act. And in response, we had the Families First Coronavirus Response Act. And this was the requirement to provide up to 80 hours of paid sick leave for a variety of different COVID reasons. And this is, I still have my giant binder back here that's still old school, need my paper response to go back to the statutes. And there was the six different reasons where you went through and had to figure out, okay, did an employee qualify for up to 80 hours of that supplemental paid sick leave? Now, the key part of that leave, if you recall, was that it only applied to employers that had fewer than 500 employees. That was the big distinction. So this was a federal requirement, and that was the one where you could get some federal tax credits, had the 80 hours. We also had the FMLA extension for up to 12 weeks for if you had a daycare, childcare closing, et cetera. Then Governor Newsom signed the executive order. The executive order specifically was for California-based employers that had 500 or more employees, because basically the governor said, okay, well, wait, this isn't fair. We want to make sure that people in the food sector industry that were larger employers, he really was targeting like fast food, agricultural, food processing really was a major target. And saying for those that are these larger employers, I'm going to make sure that they have access to paid sick leave as well. So again, larger employers in California, but that was not a legislative response, that was an executive order. So here we come now to our first legislative enactment, AB 1867. And so this was expanded supplemental paid sick leave. And essentially it did two things. It codified that original executive order. So it basically said, okay, now this is in statute. This is the California legislature saying we're going to codify that executive order. But it also expanded this paid supplemental sick leave of 80 hours for larger employers. And it's really important, that first highlight is it's for employers that have any kind of hiring entity that have 500 or more employees anywhere in the US. So this is really important for employers that maybe only have a smaller presence in California, but have a larger presence nationwide. And that did catch a number of our clients. That was the case. They maybe only had 30 employees statewide, but that had a larger presence statewide. And so those were the ones that they all of a sudden realized, okay, this bill applied to them. So again, 80 hours of supplemental paid sick leave that they were now required to provide. Similar to the FFCRA type leave, it could be capped at $511 per day. There was a cap of 80 hours. There's a lot of, again, details with respect to what is the regular rate for purposes of how much is paid. But one of the big things I really want to highlight for this is under this, this new law is look at the requirements of what it is that qualifies for the paid sick leave. Under the FFCRA, you had the 6 different reasons. Here you have 3 different reasons. And if you look at that last one, prohibited from working by the employer due to health concerns. That's a pretty broad definition. And what are health concerns? Who's concerned? So again, I want you to be very careful if you fall under that definition of an AB 1867 supplemental paid sick leave, make sure that before you automatically deny or say, I don't think that that qualifies for sick leave, that you take a look at those definitions of supplemental sick leave. This did go into effect immediately. It was a trailer bill, kind of like an urgency measure. So it went into effect as of September 19. It is set to expire at the end of the year, or if the federal FFCRA leave is extended, which it could be by Congress, then it will be extended there as well. And one of the most important, in my opinion, and something that, again, Ian will talk about later with respect to PAGA, that I think I want to make sure everyone is aware of, is that your wage statement needs to be updated. This is a key difference that AB 1867 talked about, and that is that supplemental paid sick leave needs to be a separate line item on your wage statement. Wage statements are just one of the easiest things for plaintiffs' attorneys to catch employers with respect to a violation for PAGA purposes, class action purposes. And so this to me was a really kind of almost like a little sneaky way to get a violation against employers. So again, if you fall under this supplemental sick leave, make sure that your wage statements are updated. There was also, if any of you fall under the definition of a food sector employee, make sure that you're aware that there was this additional a requirement that the employees have the right now to wash their hands every 30 minutes. And there was another notice requirement that is now published by the Labor Commissioner. All right, SB 1159. This is one of two what I think can be very complicated COVID requirements that were passed at the same time, and a lot of people are muddling them. And so I just want to keep it really clear in your mind. Again, these are pretty heavy, dense slides but I want to break out and keep them separate in your mind, because you're going to be getting, and you probably already been getting inundated by a lot of people with information about these two different requirements. So the first one with SB 1159, this is the Workers' Compensation Presumption Bill. A lot of folks got information over the summer with respect to the Workers' Compensation Rebuttable Presumption. For those of you that deal at all with workers' comp claims on behalf of your employer, you're probably already familiar with this idea. The idea is that a rebuttable presumption is the notion that, hey, when you go before the Workers' Comp Appeals Board or before administrative law judge, it's the idea that it's presumed that an injury arose in the course of employment. And it is the employer's duty, the employer's side, your workers' comp side, to refute or rebut that it didn't arise in the course of employment. It usually most often arises in public safety, firefighters, police officers. Back when I worked in the legislature, I remember, almost, every week there would be a new rebuttable presumption bill that came through. Oftentimes would be even public lifeguards. I mean, it was every type of, cancer presumption, things like that when it came to public sector employees that worked in those types of first responder type roles. So here the idea was the governor had an executive order when COVID first came out that first responders especially, and essential workers, so a lot of the folks that worked in essential worker type roles, even in food processing, grocery workers, things like that, that it was presumed if they caught COVID during those early months of the COVID outbreak, it was presumed that they got COVID in the line of work so that it was covered by workers' comp. So what this bill now does is it codifies and it kind of creates two different presumptions. One of the presumptions relates, and there are two separate labor code provisions, and it really relates to frontline workers. So one of them is Labor Code 3212.87, and it really just relates to peace officers, firefighters, healthcare workers, and IHSS workers, so people that are going into people's homes. So that's one. It's not a lot of the big bulk of our workers, so I'm going to kind of put that aside, and that really is that rebuttable presumption that's presumed if they have COVID, they got it in the course of employment. The other one is a general presumption for employees who contract COVID in the midst of a workplace outbreak. And so then that workplace outbreak honestly isn't for you, the employer, to determine. That's going to be for your workers' comp carrier to determine the outbreak. But you play a pivotal role. It's going to be incumbent on you to provide a variety of information, a lot of data and info to your carrier. And so that's why I say a lot of you have already hopefully been contacted by your third-party administrator, directly by your workers' comp carrier with what it is that they need. So a lot of them, like state comp and other TPAs, have already provided you portals or spreadsheets, things like that. Like, hey, this is the information that we need from you. So here are some of the things for purposes of this section. And this is where it's going to get kind of confusing. And this is where you're going to start seeing that the legislature did not make it easy on us as far as defining outbreaks. There's different definitions for different purposes. And here, this is one of the ways, and one of the labor code provisions as to what they define as an outbreak. Again, not really as important for you as to how that definition comes about, but this is how they defined it in the labor code for their purposes of an outbreak. And it comes back to, within 14 days, 4 employees test positive. If you have 100 or fewer employees, you look at number 3, a specific place of employment is ordered to close by a local public health department, the State Department of Public Health, DOSH, or a school superintendent due to a risk of infection of COVID-19. I found that kind of interesting, especially when a lot of us are kind of curious as to why certain school districts aren't opening, or there's a lot of concern with respect to school districts. I mean, a lot of this stuff is because there's a lot of fear with respect to liability when it comes to, you know, opening schools and things like that. All right, so what is it that you need to know? So what is your requirement? So for those of you that have ever sat through my sexual harassment training, you know from a legal standard, I love the knew or should have known standard. What is it that I should have known? Well, here the legislature is using the should have known standard again. So your duty is when an employer knows or reasonably should know, what should you reasonably should know? That an employee has tested positive for COVID. Then your duty is you must notify to provide a report to your claims administrator in writing via electronic mail or fax this information. And so again, hopefully your TPA, your whoever provides your workers' comp has provided you some kind of model to fill out this information. So the date the employee tested, the fact that they tested positive, number of employees, but you can see it's a lot of information, but I just want you to understand this is why they're asking for this information, because they have this duty to track this for determining the outbreak issue. And then you also have a duty to notify if there was that closure order. So again, if for some reason you've been ordered to close because, you know, by a local public health department, you have that duty to notify them. That data needs to be reported to your claims administrator within 3 business days. So a lot of this stuff when it comes to the presumption, again, I don't want to get too wonky into the whole how to rebut a presumption. That really is for your workers' comp carrier to deal with. But there is, I got a lot of questions, especially for like some of my grocery store clients and things like that, that were essential workers that were really upset when they would say, well, wait, why am I going to be held liable when I know my employee he also is in a band and he's you know, working at the bar on Friday night and partying with a bunch of his friends, but now he's claiming he got it at the grocery store. Well, that's information that definitely the legislature says that is information that is relevant to refute and rebut the presumption. So stay in contact with your TPA, with your administrator. I mean, this is the time to have that close relationship with your carriers and provide that information. And it is important that it's quick. These are quick turnarounds that the legislature has put the onus on the workers' comp carriers to turn this information around very fast. And so I'm not saying that you just have to throw up your hands and say, oh, it's just going to be presumed to be occupational injury. That's not necessarily the case. It's just going to be the burden is going to be on the employer if the burden of hitting that outbreak has been met. So again, this is my first of many times where I'm going to say it's important that we have someone in-house that is dedicated to tracking this information and is going to be your point of contact with the workers' comp carrier. All right, I'm not going to belabor that. There's a lot in there, but I'm not going to spend too much more time on that because now I need to switch over to AB 685. This is a separate requirement. So this is where we kind of get them mixed up, but this is now a separate duty. That one had to do with the workers' comp presumption. Now, AB 685, and that one was an urgency statute that's already been in place. You've already started tracking that information, providing it to your workers' comp carrier. AB 685, separate requirement, goes into effect January 1. Okay, the easiest way, because this stuff is heavy, the easiest way for me to break this down is AB 685 has a variety of different components in it. And for me, the easiest way to break it down is it's kind of got 3 different pots. It has one duty that requires the employers to notify employees who may have been exposed to COVID, and to report workplace outbreaks to local health departments. So this is the employer's duty. It also has a part of it that requires the California Department of Public Health to publicly report outbreaks, workplace outbreaks. And then it also has a separate component that authorizes Cal OSHA to enforce COVID hazard as an imminent hazard to provide imminent protections. Bottom line, like the short cut to all of this is it provides them immense power, in my opinion, a lot of power. So those are kind of the 3 pots of the different requirements. Most important for you, what most of our clients are really worried about is that first pot, right? So breaking that down. The first requirement of AB 685, if you just break it out, is this is where it's found, is 6409.6. It requires an employer who receives notice of potential exposure to COVID to take the following action within 1 business day. That's fast, right? Provide written notice. And you see, look, all these bolds. This is a dense slide here. We got to break it down. To all employees and the employers of subcontracted employees who were on the premises at the same work site. Notice work site is bolded there because we're going to get back to that. Of the qualifying individual, that's also defined. Within the infectious period, that's also defined. That may have been exposed to COVID-19 in a manner the employer normally used to communicate employment-related information. I feel like I'm in my sexual harassment training where we got to break this out. I mean, that one clause right there could like give anyone, a headache. Hopefully everyone's got their coffee now and you're ready, okay? That's a mouthful right there. And just to show like the legislature even was kind of threw up their hands after that, is they basically deferred and said, we're going to let California Department of Health kind of break out a lot of those definitions. So let me just at least break down some of these parts right here. So the written notice, they did say, they broke this part down in statute. So this part is in the statute. They say, okay, since we know it has to be within 1 day, it can be via personal service. So you can be, if I think about my office where, maybe we've got 20 people on one floor, it could be pretty easy. You could walk around, hand out a notice, you could send an email out, you could send a text out, pretty easy. But then you think about like a giant construction site, right? Might be a little bit more challenging. But these are different ways you can do it. It needs to be in English, both in English and any language that's understood by the majority of the employees. So I know I've got some work sites that have a variety of different languages, so that could be a little bit challenging. And then note this, I just kind of threw this in down there, but it does say this in the statute that you should be keeping copies of these notices for at least 3 years. So I would just, again, I'm recommending my clients have separate COVID files. Not like per employee, but just separate COVID files that you're just keeping all of this stuff. All right, and let's break down some of these other definitions. Work site. So this is how they've defined work site. Building, store, facility, agricultural field, or other location where a worker worked during the infectious period. So again, this is for some of you, work site's easy, like, okay, that's not a no-brainer, but I really want to highlight this because I know this gets really challenging. My properties, folks that are, managing major multi-unit properties, construction sites, warehouses, things like that. This can be very challenging. They did do this caveat that talks about multi-work site environment. And it talks about you only need to notify the employees who were at the same work site as the qualified individuals. So it's not like you need to blast it to the entire workforce just because they worked for a particular employer. You really need to just limit it to that particular work site. And they also did give this explanation of really looking at the work site and looking at where the person was. So one of the takeaways I took from that, especially for, again, a construction site or maybe a general contractor, is how important it is, which a lot of you been doing already with COVID and contract tracing, is keeping an eye on who's working, which buildings, who's been in and out. I think is going to be really important for these notices. Then, oops, sorry, a little, the infectious period. So this came out, you'll see this is, almost a month after the legislation was passed. The California Department of Public Health did issue guidance, and I did include the link below so you can find this just if you want to go to it to define some things like the infectious period, because this is different than CDC guidelines, it's different than OSHA guidelines, but this defines the infectious period for purposes of the notice. So we have to, again, be careful about which definitions we're using where. So take a look at this. I'm not going to go into great detail. You have it here, but this is where they're defining what the infectious period is, depending on whether the person tested versus having symptoms versus not having symptoms. But you can see, again, it's going to take someone really sketching out for purpose. And when you have 1 day to get that notice out, this can be a huge challenge. The notice also must include a variety of different things. And that's why I really recommend, people have been asking for sample notices. You know, I really recommend that you get in and just right now look at your policies, because it's not going to be a one size fits all, because what you have to do is put in all of these things: your particular workers' compensation rights, your COVID-19 related leave, but your company's sick leave, your supplemental sick leave rights, any negotiated leave. For example, if you have any CBA type rights, your retaliation and anti-discrimination protections. You also need to have a copy of your disinfection and safety plan. So hopefully you already have that. If you don't, you need to get somebody on that. That's something you should have already had in place over the summer, but making sure that that notice has either that attached link to it. And, you know, again, that should be per CDC guidelines. It should not notify who the employee was. Again, this is, you know, we're preserving, people are going to want to know, well, who is it? That's not for us to say, just like before. And then you do need to provide that notice to any exclusive labor representative. Okay. In addition, like I said, to the notice to the employee, if that's not confusing enough, you do also need to require to provide information to a local, any local health authorities under the code if there is an outbreak. Now, remember we talked about outbreak under the workers' comp notice requirements. This is an outbreak that it needs to be reported to your local health authorities, and it's a different definition of outbreak, just to make it more interesting. So the definition of outbreak here is 3 or more laboratory confirmed cases of COVID among workers who live in different households within a 2-week period. And that really is important. I know I've had a few of those cases with clients who have had a number of people within the same household, related or not. And so I do think that that is an important qualification. I do also think it's important to note that some of the things with respect to the notice requires that you do notify them with respect to your codes, the industry codes, and that is because they will be tracking among industries, and they now do have a statutory duty to track this information, and arguably they're going to be posting this information, and that is kind of controversial because this information will be coming out weeks later, probably long after any kind of quote outbreak occurred in the industry. And as I noted, the requirements of AB 685 also provides Cal OSHA with a lot of additional powers and rights. We have been notified. I know personally of Cal OSHA out already investigating some what they've deemed outbreaks and trying to determine whether they will be closing down certain industries. So just be aware, you do again need a point person that is prepared to meet with Cal OSHA when they do come out and be prepared to have a response, have their COVID plan in place, making sure their IIPP is updated and ready to go. This is just really, it's just serious stuff, and this can happen very quickly. And I just don't want you to be caught flat-footed, that you're prepared with the response. So that AB 685 is a serious one. Take some time, have somebody dedicated within your organization that is prepared come January 1 with the response. You know, hopefully things will get better, but if they don't, these are very onerous requirements that we want to have a response to. These next 2 slides I'm going to breeze through just in case they apply to you with respect to PPE. Again, more information, you can find the details of the statute. I'm happy to email more details. Just doesn't apply to a lot of our clients that are on this particular webinar, but with respect to providing PPE for essential workers. All right, leaving COVID, because we got to jump on to other topics. What I believe, despite what I just talked about with COVID, but what I believe to be probably the most important and in my opinion, scary legislative change in 2021. And I know it's hard to say that something was even more important than all those COVID updates, but really, in my opinion, this is a monumental change for both small and large employers. And really, if I lost you at all over the last section, I really need to get your attention here, is SB 1383, and that is the expansion of the California Family Rights Act. This is very significant. For those that haven't followed it before or forgotten, basically this is California's version of the FMLA, the Family Medical Leave Act in California, with the California Family Rights Act, which provides up to 12 weeks of protected leave for employees that need to take time off, usually unpaid time off, for a serious health condition, either for themselves or for an immediate family member. Now, historically, it only applied to employees that worked for an employer that employed 50 or more employees. So for the first time ever, now it applies to employers that employ 5 or more employees. So you think about the smallest mom and pop employer you can think of, someone that has 6 employees, you know, anyone that falls under FEHA, they now have to provide 12 weeks of protected leave under the California Family Rights Act. It changes the definition of employer to anyone who directly employs 5 or more employees. The measure also repeals the New Parent Leave Act. For those of you that know, recall about 3 years ago, the California legislature provided this kind of in-between change that provided for employers with 20 or more employees leave to bond. It was baby bonding. And it was kind of the segue, moving away from the CFRA. It was, kind of take the baby bite. And we knew this is the direction we were going. Gavin Newsom signaled this is what he wanted to do. The first partner, his wife, had signaled that everyone should have this right to protected leave. And so here we are. The bill also notably expanded the definition of CFRA family to cover domestic partners, grandparents, grandchildren, siblings, and adult children. No, I skipped over parents-in-law. There's kind of a confusing change. I think it was a legislative mistake where they included parents-in-law, but it was a messy change. So that's still subject to debate. I think they're gonna have to do some legislative cleanup, and we'll kind of skip over that one for right now. So again, who's eligible for CFRA leave? You have to work for an employer still for at least 12 months. It can be over a period of 7 years. It doesn't have to be consecutive, but your employee still has to have worked for at least 1,250 hours of service during the previous 12-month period. And it's to care for a family member with a serious health condition. So there's still some, minimum thresholds that those employees need to meet. But it really, for purposes of my small employers that have never had to deal with this before, I really just need you to think about how you're going to address this. The most important part is the idea of just recognizing that this is job protected leave. And so even if you think, oh, well, this is a hardship to have Lisa go out for 12 weeks to care for her sick mom, it's law. She has that right now, and her job is protected, and she has the right to return to her job. She also has the right then to the continuation of her health insurance benefits at that same level. So you need to maintain those health insurance benefits at that same level, and then reinstate that person to the same job or the comparable position. Now, while it is unpaid, also remember that California expanded the paid family leave to 8 weeks effective July 1. So now arguably 2/3 of that 12 weeks is paid. And so we will see more and more employees take advantage of CFRA leave now that they're up to 8 weeks of paid leave available to them. So for my small employers that never had it, make sure that those employee handbooks are updated. You need to make sure you have the policies in place, brochures, download those brochures online, making sure that we provide those to employees. And really it's getting policies in place, we'll talk about at the end, to make sure that we have those procedures, how to track it, how to document when people go out on leave. But my large employers, for those of you that are falling asleep and going, oh, why do I care? I've already been providing that leave for years. I don't really care. It does change things for you. So you do need to update your policies, because now we have changed the definition of family. It does now provide that your employees can take leave for a grandparent, a grandchild, a sibling, and an adult child over 18. It used to be only for an adult child that had some sort of special needs that where they were unable to care for themselves. Now it's any adult child. So this one, you need to update your policy to ensure that that is covered. The other interesting thing that I talked to some friends and lobbyists and other attorneys, and I kept thinking, like, there's got to be a legislative fix, because what we did is the California legislature, by changing the definition of family under CFRA, is we basically said we're different than FMLA definition of family. So they're not compatible now. So what does that mean? That means that arguably CFRA and FMLA don't run consecutively if you're taking it for one of those reasons, that one of those family definitions that doesn't run consecutively with FMLA. And my first thought was, oh, well, there's got to be a fix to that, right? And some other attorneys and lobbyists who are even smarter than I and all said, no, I don't think there is a legislative fix. So Ari, here's a scenario where, you have one of your employees who goes out on multiple leaves, maybe for a sibling and maybe for an adult child, and exhausts 12 weeks of CFRA leave. And then at the end of that has another 12 weeks to take FMLA leave for their own purposes. So, it's kind of like other PDL, CFRA type exhaustion type leaves that we've already seen. So it's something out there. So you large employers, think about that. That wouldn't apply to our small employers, but for our large employers, there is the chance to be taken up to 24 weeks of leave now. And so keep an eye out for that. Other significant changes to SB 1383, it eliminates the key employee exception for anyone that was aware of that or ever tried to utilize that exception, where you were able to say, hey, for my highest paid employee, the exception, the top 10%, that's gone out of there. It also eliminated the two-parent exception, where you were able to say, hey, if we have two parents that both work for the same company, we're not gonna let both of you take baby bonding leave. That's out of there as well. So I'm a little kind of confused how that's gonna work for some small employer that has two parents trying to take baby bonding leave at the same time. But again, California legislature, we're taking care of employees left and right, but I don't know that we're taking care of our employers. So, all right, with that, I've got one more, sorry, AB 2992, sorry, and I will hand this off to you in 1 second. Last one of mine. This was one I was gonna gloss over pretty quickly, but everyone needs to kind of pay attention to this. Labor Code 230 has been on the books for a while, and this was the idea that employees had the right to take time off if they were seeking a TRO for domestic violence, sexual assault, stalking, things like that. It's probably already in your policies, handbooks, things like that. This was amended to now say any violent crime. And so I just want you to be aware this applies to all employers. And regardless of size, it basically gives someone that took an unscheduled absence, and then they come back and say, well, it was because I was seeking a restraining order, or I had a proceeding, I had to comply with a subpoena. It's not just limited to stalking or sexual assault. So just take a second look before you take action, discriminate, retaliate. There's a separate cause of action. It also, that same bill amended 230.1, which only applies to employers with 25 or more employees. And that one has to do more with about getting services, counseling, medical attention, things like that. It also applies more broadly to victims of a variety of crime, not just sexual assault. It was even broader. It would have applied to even people that were victims of employment discrimination. And it's still, some opposition to the bill still said it was too broad because it could apply to victims who were actually the deceased, the people that actually committed the crimes, and family members of those folks and stuff. So it is pretty broad. So if you have someone that's saying, hey, I need to have an absence because I need to seek mental health counseling because my brother committed a crime, and now I'm having issues with respect to that. Again, take a look, just issue spot, realize that might be an issue, and before you take action, maybe talk to HR or take a look at this provision. So with that, I'm going to turn this over now to Ian.
Hi everyone. The first law I'm going to be talking to you about is AB 2017. And for those of you who remember, a couple of years ago, I think Lisa mentioned it, it was the Healthy Workplaces Act, implemented what is commonly referred to as kin care. Employers who provide sick leave are required to allow employees to use half their annual accrued sick leave to care for a qualifying family member. What the law changes this year, it's just a small discrete change, but it is important. What it does is it allows the employee to designate the type of sick leave that they're using, and it limits that designation to only the discretion of the employee. The reason that's important is because the law went on a couple years ago to confirm that employers are not allowed to discharge, threaten to discharge, demote, suspend, or in any way discriminate against any employee for using their sick leave for these purposes. So it is important to note that employees now have the power to make that designation, and it rests solely with them. So it may be something worth looking at if you need to revise your policies to ensure that employees are not just aware of their rights to designate their sick leave as such, but also to make sure that there's nothing that could even be construed as any sort of interference or reprisal for them using half of their annual accrued sick leave. So that's AB 2017. Next slide, Lisa. Thank you. Worker classification. As many of you might be aware, there was somewhat of a sea change a couple years ago when the California Supreme Court decided a case that's commonly referred to as Dynamex. Previously, there had been another test for determining the status of an employee, or excuse me, a worker, and whether or not they were an independent contractor or more properly characterized as an employee. And what the California Supreme Court did in Dynamex was implemented what's commonly referred to as the ABC test. I won't bore you by reading it, but it's there in the slide. And like I mentioned before, this was somewhat of a sea change because it really upended quite a bit of the jurisprudence regarding how you analyze the relationship between the worker and the employer. And almost immediately after implementation, the assemblywoman responsible for getting AB5 through said that there needed to be significant changes. And so this year, AB 2257 represents the culmination of that process and the changes that were made to AB5, even though it was only implemented, I think, just a year ago, right? They've already made substantial changes. Importantly, the analytical framework from Dynamex and AB5 is going to stay in place. So the ABC test is still the default test for determining whether or not a worker is an independent contractor or a employee. But with that being said, in AB5, there were numerous exemptions that carved out specific relationships, specific, even just not classifications, but occupations. And those are some of the changes that Ms. Gonzalez said needed to be reviewed. And so to a certain extent, AB 2257 represents, the lobbying effort of these different industries and occupations, trying to ensure that they are treated differently and not subject to the ABC test, but rather the former Borrello test that was in place prior to the Dynamex decision. And so I've listed a couple examples, but in part, it's just to highlight what is almost the absurdity of the new law. And you can see registered professional foresters, referral agencies, some count, some don't. I mean, it's really granular, the level of detail that this bill reaches down into. And so the main takeaway here is if you do have an issue where you're not sure if your relationship with a particular worker passes muster, and that you're properly characterizing them as an independent contractor, that really is something that you need to contact counsel and take a very close look at, because the overarching purpose of AB5 when it came out was to tilt the balance in favor of characterizing workers as employees. And that's still, like I mentioned, the default. So, but as you can see, the granular level of detail here and just the nuance of this statute and the fact that it's continuing to evolve really necessitates contacting counsel if this is an issue for you and your workforce. And I think with that, the Consumer Privacy Act, this went into effect about a year ago. The purpose of the statute was to give consumers in California more control over the personal information that businesses collect from them. In short, the bill is designed to give consumers different rights: the right to know about the personal information that businesses are collecting, the right to delete personal information collected from them, the right to opt out of the sale of their personal information, and then it also ensures that consumers won't be discriminated against for exercising their rights under the CCPA. And importantly here for employers, originally the CCPA contained a one-year exemption for data collected from California residents in their capacity as employees, applicants, and independent contractors. So the type of information that you would receive if they were applying to come work for you. That was originally set to sunset at the end of this year. But what AB 1281 does is effectively kick the can down the road, and it continues that sunset from December 31st, 2020 until January 1, 2022. And just as a reminder, the CCPA does not apply to everyone. It only applies to for-profit businesses that meet one of several criteria. The most well-known is probably the gross annual revenue has to exceed $25 million. But if you're in the business of buying, receiving, or selling personal information, then if you have more than 50,000 California residents or households as customers, it could apply to you. Or if you derive 50% or more of your annual revenue from selling personal information of California residents, then it could technically apply to you as well. But really, it's that first threshold issue of whether or not your business has gross annual revenue of $25 million or not. But so who it applies to, what it requires, those all stay the same this year. But thankfully for employers, what 1281 does do is extend the sunset on the exemption that would make that type of data collected from the employee in the context of the employment relationship. Of course, if your employee is for some reason also a customer of the business, then this exemption would not apply to the type of data collected under those circumstances. It's limited to information and data collected in the context of the employment relationship. But at least for one more year, even that data is exempted under 1281.
Good morning, everyone. I hope everyone's well and dealing with this new virtual reality we're living in relatively okay. So I get to talk to you guys about some different enactments that are a little bit more closely tied to litigation. So one of the first ones we saw here was AB 1947, which essentially extended the statute of limitations that employees had to file discrimination and retaliation-based claims with the Labor Commissioner's Office. And then also that same provision or that same bill authorizes a civil court to award reasonable attorney fees to an employee plaintiff who brings a successful action for a violation to the right to disclose information that the plaintiff, and here's kind of the catch, a reasonable cause to believe concerns a violation by the employer. And so that particular language is kind of interesting, and you can see here that in our takeaways that something to note is that employees have a little bit more of an incentive to bring additional whistleblower actions now with this new provision, because they don't actually have to complain of an actual violation so long as there's a reasonable cause to believe it concerns a violation. Presumably they might get lumped into that. So we could see an uptick in the amount of whistleblower actions that get lumped into civil actions. And then also with the extension of the statute of limitations in the Labor Commissioner's Office, we could also see an uptick in the number of those proceedings as the years come. So then we're going to touch a little bit on meal and rest periods. So we had some interesting updates that are very specific to different industries. So AB 1512 deals with the security guard, if you're a security guard employer or a security employer, and then AB 2479 deals with if you're in the business of being safety sensitive petroleum facilities. So these are hyper specific kind of updates to the law that really don't apply unless you're in one of these two industries. And just to touch on AB 1512 here, this seems to have been a direct response to the ABM Securities Supreme Court case here in California. For those of you who know or don't know, that case involved a group of security guards who on their rest periods were required to remain on call, and in the event of an emergency or they needed to return to work during the rest period, that the court in that case took issue with the fact that these employees often were not provided their full 10 minutes break and were often in fact working still. And so AB 1512 seems to be kind of a response to that, which allows on-call rest periods for employees or security guards, and that will satisfy the obligation of the employer so long as, you know, that break is not interrupted. And there's kind of a catch in the new law that if indeed one of the rest periods is interrupted when you're on call, the employer has an obligation to allow that security officer to restart a rest period anew as soon as practicable after that. And similarly here in AB 2479, it's the same concept where if an employee is interrupted during their rest period for any reason, again, the employer has an obligation to allow that employee to restart a rest period at a later time. And so those are kind of some specific updates to some specific industries on rest breaks. This was a kind of a new change and an interesting change that the legislature seemed to enact in response to some practices they were seeing by healthcare employers. So for those of you who are in the healthcare industry, this may be of particular relevance to you. And so this was enacted because the legislature, I believe, noticed that a practice where employers were requiring employment applicants or existing employees to pay out of pocket for training programs mandated by the employer themselves as a condition of full-time employment. And so AB 2588 is kind of a response to that, and it essentially applies the employer's obligation to reimburse employees for business-related expenses to the concept that employers are mandating certain training or other requirements in terms of full-time employment. So specifically, you see here that AB 25 requires reimbursement to any expense or cost of employer provided or employer mandated educational or training for employees providing direct patient care at a general acute care hospital, as well as applicants for such employment.
And Dylan, if I could just interrupt real quick on some of these really specific bills. I know it's easy to kind of tune out for a lot of employers, like, okay, well, we're not healthcare employees. And that's true. These don't specifically apply to you, but you could start seeing these themes, like what the legislature is doing. So on this one, they're basically telling the healthcare industry, you have to pay if you want your applicants to be CPR certified and things like that, to have these different trainings. Like, that's crazy. Like, you have to pay for applicants to have for their certificate. That's a wild thought. And while this doesn't apply yet for construction employers or other restaurant employers and things like that, but just start thinking about, oh my gosh, what other types of things are we requiring our applicants to have certifications for before? And I'm not saying change your practices yet, but just start thinking about it. And again, when I say get involved in your trade associations, start thinking about those types of things before they become law, because these are those types of changes. And even like with the one that Dylan just talked about with rest breaks and interrupting rest breaks and things like that, those are the types of things that, yeah, we have to get involved, because those are the class actions that start hitting all of our industries, and we start seeing multi-million-dollar, class actions on this kind of stuff. So just my 2 cents.
So here in California, we also saw a kind of a new requirement to submit pay data to the DFEH. And so this is somewhat interesting. And to those of you who this may have been applicable to before, you were likely submitting some version of this report already to the EEOC at the federal level. And so originally at the federal level, there were 2 components of this data reporting. There was, I believe, component 1 and component 2. And I believe component 2 was not recently renewed by the EEOC. And so California kind of attempted to legislate and fill that void here in California. So this new measure essentially requires private employers with 100 or more employees to submit an annual pay data report to the California Department of Fair Employment and Housing. And again, this was something that if if this is applicable to you now, it was probably applicable to you before, and you were providing some version of this to the EEOC. And so covered employers under this law will be required to report the number of employees by race, ethnicity, and sex for certain job categories. Again, those are the same categories we saw in the EEO-1 form. And so this is kind of somewhat interesting, although not drastically changing, because this was something that a lot of employers were providing before. But it is somewhat interesting that California kind of went out of its way to make sure it filled that void. And it is something to consider looking at as you compose these reports and start to see if, indeed you do have specific discrepancies among any of these potentially protected classes. It is something worth noting, and, kind of knowing that now not only will the Equal Employment Opportunity have this information, but also state agencies here in California will have access to that as well. And so just so for all of your records, those paid data reports are required to be submitted on or before March 31 of 2021. So if you think this is something that is applicable to you, it is something to start thinking about. And then here in the prevailing wage and public works realm, we kind of had an update, somewhat of a prominent update in terms of public works projects and prevailing wage projects. So for those of you who are engaged in either doing public works or have worked on public works projects before, recently in the labor code, there was a definition added for what was previously known as de minimis. And so it kind of codified a definition, as opposed to there was certain authorities that lended attorneys kind of somewhat of an argument to determine what was de minimis for purposes of determining what level of a public subsidy triggered prevailing wage requirements. And before that, that authority was always thought to be about 1.75% of the total project cost. If you received a public subsidy that was less than that or up to that, you were thought as being safe from kind of having your otherwise private project lumped into a public works project subject to prevailing wages. And so under this new law, we get a little bit more specifics from the legislature in terms of what is going to be constituted as de minimis for purposes of a public subsidy triggering prevailing wage requirements. And so under the new law, we saw the general definition now is going to be that de minimis is a public subsidy, or it is de minimis if it is both less than $600,000 and less than 2% of the total project cost. And so that's interesting just from the perspective that before we were always just looking at a pure percentage in that 1.75%. So once you also have this cap of 600,000, you start the wheels start turning that, once you get into these really big public works projects that may be over a certain amount. For example, I believe any project over 30 million, you can anticipate having a ceiling of 600,000, and that potentially could present a challenge. For instance, if you have a $50 million project, 2% public subsidy on that project is going to exceed that $600,000 ceiling. And so kind of the one exception that seems to be put in that definition is that a public subsidy for a residential project that consists entirely of single family dwellings is de minimis if it is less than 2% of the total project cost. So just as it relates to residential projects consisting of single family dwellings, it seems like the requirement there is only the 2%. So in theory, that project, your public subsidy could exceed the $600,000, but that's kind of the only carve out we have seen so far in this new update to the definition. And I think with that, I'm going to turn it back over to Ian for some regulatory updates.
Need to unmute myself. Hey everyone. So just want to touch on some broader regulatory updates as well, beyond just very specific new laws. The first one, minimum wage, it's going up again. Right here, we've got the actual increases from 12 to 13 for employers with 25 or fewer employees, and 13 to 14 for those of you with 26 or more employees. Takeaway is just to make sure that your payroll practices remain in compliance. Just wanted to emphasize too, especially for the folks in the construction industry, the minimum wage is important because of course you have to pay the minimum wage for all hours worked, but there's other issues that kind of get triggered by the minimum wage. So for example, in wage order 16, which is the wage order applicable to the folks in the construction industry, there's a carve out that says you're allowed to require employees who make more than twice the minimum wage to provide their own hand tools. And I believe the exact verbiage is, equipment customarily required by the particular trade or craft. Well, if the minimum wage is going up, then potentially you're going to lose some employees and who are no longer making double the new minimum wage. And now you're no longer allowed to require them to provide their own hand tools and equipment in those instances. And particularly given what we'll be talking about in a few slides with the type of litigation that we're seeing a lot of claims under Labor Code Section 2802, where employees, for a variety of issues, are claiming that the employers are not reimbursing them for all necessary expenditures. That could be, mileage, driving in a car. It could be using their personal cell phones. But we've also had cases, several of them over the last month, where purchasing their own tools, using their own equipment is front and center. And there's not just the underlying claim, but then of course the liability potentially triggered under PAGA. And so this is one where it's important because you do have to stay up to date with the minimum wage. And as it increases, it does affect which employees are or are not subject to that provision in wage order 16. So it's not just the minimum wage for all hours worked, it's also collateral issues that you need to stay apprised of. Poster changes, this one's fairly straightforward. Many of the laws that we have been discussing over the course of the first hour are going to necessarily lead to new posters. So you just need to continue to monitor, DIR, EDD, the different websites, and make sure that you are posting the most recent versions. Here's a list of some of the posters that should be changing based on some of the changes that we've described. For example, the minimum wage notice, the family care and medical leave and pregnancy disability leave poster. These will be changing. Another important thing to remember is if you are in the circumstance where your employees are 100% remote, and that means they are never coming into the office, because if they, sometimes come in, then you're probably okay. But if you have employees who are now 100% remote, in order to comply with the regulations, you may want to consider mailing hard copies to ensure compliance, because the thought being, if they're never here, in order to make sure that they are aware that you've met those obligations, it might be just simpler to mail them a copy than deal with an issue later down the road. Next slide, please.
All right, with that, I will take it back. I wanted to just highlight a couple of regulatory updates following the passage of SB 1343. Most of you will recall a couple of years ago in 2018, SB 1343 was passed, and that was in follow-up to basically almost a decade or more than a decade of compliance with AB 1825 compliance. That was sexual harassment training compliance that applied predominantly to employers with 50 or more employees that had to provide the 2 hours of supervisory harassment training. And after passage of SB 1343, that was now provided to employers with just 5 or more employees, had to provide supervisory harassment training and now a 1-hour employee training. That deadline got kicked out because DFEH was unable to meet the obligation that the legislature had put on them to provide an online training portal to January 1 of 2021. Just to update everyone, DFEH does have that training available now. It is available online, so everyone does have access to that. And so that obligation does stand. January 1, 2021, all employers do need now to comply with those requirements. So hopefully everyone is up to speed. Moreover, as part of that statutory update, they did mandate that the regulations be updated. And just as of literally last week, the Department of, or actually the Commission, the Fair Employment and Housing Commission, adopted their regulations. So the rulemaking process had been going on for the past year, and we had been monitoring it because there were some interesting proposals that had been going through, and these are where it stands now that were adopted last week. So the most important updates I want you to be aware of is that now employers do have to have in their policies a link to the department's website address for the harassment online training course. So regardless of whether you provide your own training, if you bring someone in-house, you use a online portal somewhere else, or you use the department's free online training course, you still have to provide that link in your policy. That's part of the regulations now. It also specifically sets forth in their regulations that the seasonal, temporary, or other employees that are hired for less than 6 months, that employer must provide that training within 30 calendar days. So this is really a challenge, especially for some of our clients that have, for example, summer work. You know, you hire a bunch of lifeguards, or you hire a bunch of field workers or something along those lines. You really need to kind of plan ahead of time. How are you going to get that training? Is it, some of our clients have done a great job of just making it part of the onboarding, especially the 1 hour for the employees, sit everybody in a conference room and you know, play the tape online, you know, whatever it is that you can do. They also confirmed that the training can be done in segments, and that was something that was put forth in the statute. Then there was some pushback, some questions, so the regulations just clarify that it can be done in segments as long as combined it meets or exceeds the applicable hourly requirement. This is helpful for those sometimes in construction that want to do like tailgate type meetings, do some 15-minute segments. Not a bad idea to constantly bring up that issue. It's one of these things that I'm going to put it out there again. It's, for those of you who have heard me say it, especially in predominantly male environments, you think, oh, we don't need to talk about it. Harassment is not an issue. It is an issue, and it continues to be an issue, especially males complaining about harassment. It has nothing to do with sexual desire. I just continue. And not only is it the law, your workforce needs to be trained about how to report and how to talk to each other about harassment in the workplace, especially in the construction industry. The other kind of nice part, though, and I've gotten this question, this was set forth again in the regulations that talks about multi-employer work sites, especially if you're part of a collective bargaining type agreement. A few of our employers have this in the construction industry, and it talks about being able to meet the training requirements. Again, work through your unions to ensure that you're meeting that requirement, but it is set forth expressly in the regulation to get those requirements met there. The most interesting, though, this is the reason I was tracking it very closely, and it did get watered down to be kind of a nothing, but I want you to be aware of it because I do think this is going to continue to be an issue, is this provision. As of July, the way the regulation was written was that employers were required to have, if you employed a minor, you were required to have a parent attend the sexual harassment training with the minor. So I was fascinated by that, especially as a parent of teenagers. So I was thinking, oh, this is going to be interesting, going to all the sexual harassment trainings with my teenagers. It has now been watered down, and this is the way the language reads. So you, employer, you may train your minors between 14 and 17 years the same way you train everyone else, or you may train them differently. If you think that's not, your normal training is not appropriate for your minors, you can do it in a different manner. And they may be accompanied by a parent, and that's all it says, is they may. So I don't know if it's at your discretion, the parent's discretion. I think that's going to be determined, but that was just amended. It had said must be accompanied by a parent, and it was amended, tweaked, changed after some pushback to just say may be accompanied. So that's where the regulations stand. They're going into effect January 1. I do think we're going to see some interesting updates. I have been called into more investigations. I think it's a challenge when you employ minors when it comes to harassment claims. So I do think that if you do employ minors, it is something where you need to keep at you. They need to be trained. It also has an issue if you, for whatever reason, employ minors under 14. There is another carve out. That's a very rare exception because of work permits and things like that. So I'm not going to delve into that, but reach out to me if you want to talk about that. All right, with that, we're going to just run through some legal trends we're seeing in the courts. We're really not spending a lot of time here just because we had so much legislatively to get through this year, but I did want to just highlight, I'm just doing one slide on COVID litigation. Obviously, it's really early. We are seeing litigation. It's early to see trends, but we're seeing a lot of different types of claims nationwide. We're just kind of, all practitioners are just fascinated to see where this is going. We're interested. Some of the claims we've seen pop up and we're reading about are FFCRA interference. Hey, I wasn't able to take my 80 hours for whatever reason, my employer didn't let me. They didn't think I qualified for it, things like that. Discrimination, Dylan's gonna highlight a case like that. Hey, I wasn't, or maybe I was laid off and I was chosen first because of fill in the blank, my age, my gender, my race, whatever. I wasn't returned to work because of fill in my protected class. I haven't been accommodated during COVID. Violations of my leave of absence protections. This is why it's gonna be really important to track leave of absence rights. Retaliation, whistleblower. I complained about we didn't have proper safety protocols. We didn't have a clean work site. They brought us back too early. You know, a variety of different whistleblower or retaliation type protections. I know that's a hard one for my essential workers. Hey, we need to get the workplace working. We need to get people back, but we've got people that are not comfortable coming back. How do we deal with that? You know, that is a concern. And then this last one I just had to throw out there because this was a case that just got thrown out last week in New York. We had a high profile case against Amazon, and the New York federal judge actually denied the case against Amazon. It was claimed a public nuisance claim. And they filed it against the Amazon warehouse saying that it was a public nuisance, making them come back to work in the warehouse. And the judge said, you know what, this is better off at OSHA. This is, we don't do these workplace safety type issues. So he kicked it in New York. Who knows if it would survive in California, but I thought that was kind of a novel theory. So again, not sure where some of these cases are gonna go, but I'm sure, as I've told some of you, we don't know what a jury is going to do with some of these cases, a year, 2, 3 years. We don't even know how long it's going to take to get a jury the way these cases are going. But I'm going to turn it over now to Ian to talk about some trends in PAGA litigation.
Thanks, Lisa. The trends in PAGA litigation is that there's a lot of it and it's increasing. It is not slowing down. For those of you that don't know, PAGA is the Private Attorney General's Act. It was a law enacted in 2004. And effectively what it does is it deputizes individual workers in California to sue on behalf of the state to collect civil penalties for violation of enumerated labor code violations. And for all intents and purposes, they're the main labor code violations that you would see in any garden variety lawsuit. So I've listed some common violations here: failure to pay minimum wage, overtime, provide meal periods, rest breaks, failure to reimburse expenses, like I mentioned before, failure to provide accurate wage statements, which is often derivative of one of those initial violations, and waiting time penalties, which is the claim where if the employee claims that they haven't been paid all of their wages when they separate, they can collect up to 30 days of pay. And we are seeing more and more of these cases. Oftentimes, even though that's 7, 8 different causes of action, they're usually tethered or often tethered to a single employment practice. For example, for some reason, we're getting a lot of travel time claims at the moment. So particularly for the folks in the construction industry, as you know, you don't often work at one job site. Employees travel to different job sites depending on where the work is. And we're seeing an uptick in claims where employees are claiming that because they are required to travel greater distances to some of those job sites, that they should be compensated for such time. Now, typically your commute is not compensable time, but there is an opinion letter from the DLSE that if it's unreasonably extended travel time, then it can shift over into compensable time. And those are really problematic because they have a cascading effect. The employee says, you need to pay me for the 2 hours or 1 hour it took to drive to the job site. So right off the bat, that's uncompensated time, a minimum wage violation. But if they're correct, and the employee goes and works a full day, and then they get credit for the hour or the 2 hours or whatever it is, drive time in the morning. Now on that particular day, you've pushed some of those hours into overtime. So now there is an overtime violation. Potentially, it causes the meal periods and the rest breaks to become untimely, because now if you're on the clock from 5 in the morning instead of 7 in the morning, that meal period that you took at 11 or 12 is no longer timely. Also, depending on how long the drive took, you could even trigger the obligation for second meal periods and third rest breaks. And it just continues to have a cascading effect with the wage statements and then, of course, waiting time penalties. And so we're seeing more and more litigation like that, where, oftentimes it's tethered just to a single particular policy, but these derivative claims just stack up. And that's important in the context of PAGA litigation as well, because under PAGA, the employee is, at least the plaintiff's attorney will argue, they're entitled to collect a penalty for each and every one of those violations. And it's only one per pay period, but per employee, depending on the size of your workforce, it can escalate exponentially. And so a very small violation, if it's widespread and applies to the entire workforce, all of a sudden the default penalty under PAGA is $100 for the initial violation. If there's a penalty specified elsewhere under a different statute, then that penalty would apply, but usually it's the $100 default. That multiplied by the number of pay periods, multiplied by the number of employees, all of a sudden you're talking really big numbers really quickly. And if you could go to the next slide, Lisa. One of the problems too is that every time one of these cases actually is litigated, because most wage and hour cases, let's face it, they get settled because nobody wants to spend the time, the effort, the money litigating a case and then potentially be stuck holding the bag for plaintiff's counsel's fees as well. But every time one of these actually is litigated and appealed, the courts are almost always coming down on the side of making it easier to allow employees to continue to bring these types of lawsuits. One of the more recent examples from last year, it was an open question whether or not an employee who had settled their individual claims for labor code violations could still proceed as a plaintiff in a representative action on behalf of similarly aggrieved employees under PAGA. And in Kim v. Reigns International, the California Supreme Court confirmed that they could. So that means people without any underlying claim, they've already settled them. They're still allowed to file these representative actions on behalf of potentially the entire workforce to collect these civil penalties, 75% of which goes to the state, 25% of which goes to the employee. But the people who really make out like bandits are the plaintiff's attorneys, because they're taking a percentage of the whole thing. And so there's real perverse incentives for them to really aggressively pursue these claims and really aggressively pursue what can really only fairly be construed as technical violations that cause no injury to anyone. But just the way that the statutes are cobbled together and interpreted, even technical violations, forgetting to put an employer's address on the wage statement, including or failing to include an employee's ID number on their wage statement. The wage statement ones particularly, it just takes a single violation, excuse me, for liability to be triggered. And then usually because employees are all receiving the same form of wage statement, it's going to be widespread, and those numbers can just escalate tremendously quickly. So based on, a lot of what Dylan was talking about, some of these changes to meal and rest periods and other laws, it's like Lisa mentioned, with your wage statements relevant to the paid sick leave, it's really important to stay on top of these developments and make sure that your practices are incorporating these changes, because it's such low-hanging fruit for plaintiff side attorneys to come in and, even if you are squared away on your policies, if they find that one technical violation on the wage statement or whatever it may be, they can really do quite a bit of damage with real minimal effort on their part. So unfortunately, the takeaway is that we're seeing more and more of these because of how easy it is for plaintiffs' attorneys to bring them. A lot of the procedural hurdles that you would typically have to clear in your traditional class action, most notably class certification, they don't apply in PAGA. And so it's just every incentive, like I mentioned before, tilts in the favor of the employee and particularly the plaintiff side attorneys to really aggressively pursue these types of actions. So really important that we all stay on top of our policies and procedures given the damage that even harmless technical violations can do.
All right. Well, on that somewhat grim note, Ian, on getting nagged for every technical violation an employer makes, I think trends in litigation in 2020 would not be fitting unless we continue to talk more and more about the implications COVID and the pandemic have on the workplace. So, some certainly interesting things to consider in the COVID era, especially as it relates to discrimination and harassment. We've already started seeing a slew of civil cases as well as demand letters and inquiries from plaintiffs' attorneys, which are some way or another kind of revolving around the pandemic, COVID, and everything related to coronavirus. And so recently there was a case here filed in California. You can see here in my second bullet point, a former employee actually filed a lawsuit claiming religious discrimination. And this case in particular is kind of somewhat of an interesting caveat to some things that employers might not consider when, thinking about discrimination claims and the interplay COVID might have on certain things. So this employee in particular, his mosque was closed down and ceased doing its regular community prayer that it did on Fridays due to the COVID-19 outbreak. And so kind of to combat that, the employee began praying in the workplace. And so upon being subsequently terminated sometime thereafter, he ended up bringing a discrimination and retaliation lawsuit, largely arguing that it was based on the fact that he was kind of forced to pray in the office, and that was a form of religious discrimination. So that's kind of one of the interesting things that we might see come out of the COVID era, as well as we've seen a number of cases come along, and this is somewhat interesting as I know a lot of businesses have been particularly impacted by COVID-19 and have had to unfortunately either lay off employees or put them on a kind of a temporary leave until the business is able to recover. Some things that employers need to consider in rehiring or bringing those employees back is if you're not bringing everyone back, you certainly need to be somewhat objective and considerate about the employees you're bringing back. We've already seen certain allegations where, for example, employees claiming that only the male employees were hired back, or only the female employees were hired back, but not the males. So to the extent that, you laid off employees before and you're thinking about bringing back a portion of your workforce, it is certainly prudent upon you to look and make sure that you're using somewhat of objective criteria and bringing those employees back into the workforce. And then at the national level, we had somewhat of a significant update. The U.S. Supreme Court recently recognized discrimination against gay and transgender employees under Title VII, and so offer some protection for that. That was somewhat of a significant update. That was something that was previously protected here in California. However, much of the country kind of left that area of the law unregulated, and it was thought to be kind of outside of the scope of Title VII until the Supreme Court came along and disagreed with that interpretation and provided protection to those protected groups of employees. And so from a national standpoint, that was somewhat of a significant decision rendered. And so with that, I'm going to turn it over to Lisa so she can look in her crystal ball and tell us what we have upcoming for 2021.
Well, in the last few minutes here, yeah, we always like to end with kind of what to expect. I was joking that we looked back and said, okay, well, what did we say last year that what we were expecting in 2020? And then we went through and we're like, well, check. Yeah, we did get at least a number of the things that we said last year that we expected this year did happen. Expansion of FMLA type leave, expansion of paid family leave, carve outs of AB5, et cetera. So we're going to go ahead and predict some of the ones that we predicted last year that didn't happen. I do still see the right of recall as a hot issue. This is that idea that was vetoed. It's been adopted in some of the cities, LA, Oakland, San Francisco. And this is the idea that it's kind of like a union first right to recall that they're trying to adopt. Again, some of the local governments have done it for hospitality type industry, that if you lay someone off in a certain industry, they have the right to recall those people first before you have the right to rehire. I have a huge problem with that in a free market, but stay tuned. I think there's going to be some more legislative proposals that we'll see there. I do think we'll see more expanded paid sick leave. I don't see any way around it. I just continue to see more push to expand paid sick leave. So I do think that it is worthwhile. I'm going to give you a little to-do list. We're going to run a couple minutes late here, but I'll be fast. But to take a look at, for those of you that still do a PTO policy, it may be worthwhile to take a look now and look to break back out to have a separate vacation and sick leave policy. The PTO policies are getting fairly muddled. Again, under California law, employees do not have a statutory right to vacation. And those of you that are very generous with your PTO, sometimes you don't get enough credit by being that generous with PTO. So maybe carve out that sick and whatever statutory right employees have for sick, follow those statutory rights, and then figure out what you want to offer for vacation. But let's follow whatever it is from a sick leave and just do those kind of bare minimums. And then be generous over here on vacation if you want, but you have more ability to control vacation when it's not a statutory obligation. These sick leave requirements and supplemental sick leave, you don't have a lot of ability to control, and there's a lot of retaliation protections and things like that. So it's just something to keep an eye out. A couple of other things that I'm just thinking that, again, predictable scheduling is still a big issue, especially in retail, restaurants, things like that. It's going to be kind of a nightmare with COVID. Marijuana is always on a few of the members' watch list. So a few things that we'll look at. My last two slides here, I swear I'm wrapping up, but some best practices. I'm just going to hammer it again. I just cannot emphasize enough to conduct timekeeping audits. Even if you did one a year ago, do it again. For those of you that, like I said at the beginning, if you registered early, we sent you a nice little link yesterday. So take a look if you deleted it and you didn't use it. It had an individualized link to go get a Starbucks coffee on us. If you're not a Starbucks drinker, and you have someone in your office that you want to hand off some of these assignments, give them that Starbucks link and say, hey, I need you to help me out. We're going to do some of these things together. Do an audit of your timekeeping practices. And I don't care how many of you say, hey, we have a great, we have great payroll already and they take care of all that. I don't care. That's a separate issue. Look at how your timekeeping is kept. Just like Ian said, PAGA is not going away. And these lawsuits are so easy for plaintiffs' attorneys to file. It literally takes nothing to do. So take a look at how you're keeping time, how you're tracking overtime, making sure that HR is talking to payroll, payroll is talking to the field. A lot of people are being sold on these apps. You know, that's great. Apps can be great, but there's a whole other host of problems. And I just want to make sure someone in-house is really looking at how this stuff is working. Take a look at how you're calculating overtime. Are you calculating regular rate? We went really in depth over the last 2 years when there was the DART decision and a lot of different court cases that came out with calculation of the regular rate. And if this means nothing to you, maybe drop us an email later, or take a look at what regular rate is. But that continues to be a sticking point for a lot of employers, and again, a spot to catch employers again for PAGA litigation. So if you have any kind of bonus type issue, flat rate type bonuses, it could be very minimal type, hey, a little weekend, $10 extra pay type thing. Those are things that we need to talk about as far as calculating into the regular rate that we want to take a look at. Take a look at your telework policies. For those of you that have already been dealing with it, you may have to be dealing with it again in the winter months. If you didn't have a good telework policy and you think, hey, this may be coming up again for us, take a look. Let's see what works for your particular workforce. What are you gonna have to craft new policies, reimbursement, things like that. What about tracking meal and rest breaks? What about people that are remote? What about people that are, non-exempt and working in the house? A lot of people are saying, well, why do we have to worry about? Of course, they're taking their rest breaks. Of course, they're taking their meal breaks. I'm right now litigating a case of an outside sales worker that has, even before COVID, saying that he didn't get his meal periods because he wasn't spending more than 50% of his time away from his home office. He was making a lot of money, but he was saying that he was not spending more than half his time away from his home office, so he's entitled to overtime and meal periods. Well, think about during COVID, who's spending more than half their time away from their home office? So a lot of things to be thinking about, especially during COVID, that you want to take a look at. Like we mentioned before, reimbursement, for telework, office supplies, internet. Are you making employees use internet? Are you making employees use cell phones? We're doing a lot of talk of now, again, not just about using personal cell phones, but using apps, whether it's timekeeping or other applications on their phones. A lot of employees want to use their own phones. I get that, but do we need to reimburse, not just for the phone, but for their monthly service? Update your harassment compliance, make sure that we're tracking that. And then also one of the things that Ian talked about with PAGA is the off the clock work. That's another thing. How do you track off the clock, right? Because they're off the clock. But are they checking on emails? Do we have proof that they're emailing you after hours? They're working from home. It's not that big. You don't even think they're working a full 8-hour day, but you're getting an email maybe at 7 o'clock at night, or they're loading the app at 5:30 in the morning. Those are the first things plaintiffs' attorneys are going to jump on. What about walk time? Do you work at a big construction site or a manufacturing plant? It takes time to walk one place or the other. There's been a prolific uptick in case law where it talks about walk time or having to check bags, things like that. So just start thinking about your workforce and this idea of, again, the de minimis time. We talked about it a year ago with the Starbucks decision, but any of that little bit of time that you don't think adds up to a lot, but it could be when it comes to litigation. So my last slide here, just again, best practices. I do think 2021 is going to be a challenge for everyone when it comes to tracking leaves of absence. So whether it's just paid sick leave, COVID leave, or now this new, what I think is going to be an increase with CFRA and FMLA leave. Remember, when it comes to the FMLA and CFRA leave, it's not just blocks of 12 weeks. It could be intermittent leave. So it could be the person that says, I just need 1 day a week off, protected. I now want to go down to a 4-day work week with full health benefits. How do you track that? Do I need to update my policies? How do I have anyone in-house that can do this? So again, I really encourage you to get a team in place, look around, look at your group, see if there's any additional resources you can bring in. Who can you rally within your organization to say, hey, we need to bring more support in-house, and also if we need to rely on support outside of our organization as well. So at the end of the day, we love our motto, but I really do believe it. You guys have been doing a great job. It's been a very, very challenging year, but we're there to support you and really do try to keep the workplace working, whatever we can do to help. As we said, we will send the slide deck out and try to answer some questions. I know we went a couple minutes long here, but like I said, there's a lot to cover this year, but we'll be with you into the new year and try to do our best to navigate through these challenging times. So thanks for joining us this morning, and we'll be here together into the new year. All right, take care.